Good morning, everyone, and welcome. Thank you for joining us today. I'm Sarah Waits, Head of Culture and Engagement at Bender Insurance Solutions, and I'm excited to welcome you to another BenderU educational webinar. Today's topic, Workplace Investigations, Getting It Right from Start to Finish. We're grateful you've chosen to spend part of your morning with us, and we hope you leave today's session with valuable insights and practical takeaways you can bring back to your organization. Before we get started, I have a few quick housekeeping items. If you have questions throughout the presentation, please drop them into our Q&A section at any time. We encourage participation and want this to be as interactive as possible. We'll answer questions throughout the webinar when appropriate and save additional time at the end for discussion. You are currently in listen mode only and will remain muted during the presentation. Today's session is also being recorded, and we'll send both recording and a copy of the slide deck to all attendees following the webinar. Now the fun part. We have an incredible expert sharing with us this morning, and introduce them. I'd like to hand it over to our Vice President of Alternative Risk Markets, Roland.
Good. Thank you, Sarah, and good morning, everybody. It's my pleasure to introduce Alex Sperry. Alex is an employment attorney, certified workplace investigator, and workplace training professional with over 20 years of experience, who helping organizations navigate complex employment matters in California and beyond. As the owner of the law office of Alex Sperry, he also provides impartial workplace investigations, employment law training, and executive coaching to public and private sectors. In addition to his legal practice, Alex is a published author on employment law and workplace compliance. His publications include Reasonable Accommodations and Job Applicants, and here is something I love, Sexual Harassment in Dentistry, Getting to the Root of the Issue. Love it, Alex. Alex, thank you for joining us, and look forward to hearing more about this topic.
Thanks so much, Roland, and I'm happy to be with you. It's a privilege talking with you and everyone there today. So let's jump in. The topic for today is, should you bring in an outside attorney investigator, when to hire, what to expect, and importantly, mistakes to avoid. So as Roland introduced, I am an employment lawyer. I've been doing employment law my whole career, going on about, 25, 26 years now. I started out as a management side litigator, and then happily gave that up to find this wonderful work where I don't have to get involved in the battling in court anymore, but hopefully I can bring value to my clients by helping them find out and understand when there are issues in the workplace that they can resolve to make everything a little bit better for folks. So that's what I primarily do now, is operate as an independent workplace investigator, and I'm going to talk to you sort of about that process today and when someone's services like mine might be worthwhile. So with that, let's jump right in. I like to start all my discussions kind of with a roadmap of where we're going to go. So I'm going to talk to you this morning about why employers, first of all, are required to do investigations. We'll talk about laws and policies that might be triggered that necessitate an investigative process. We'll talk about some core principles that guide all investigations, what your investigations, whether done by outside investigators like myself or internal folks, what they should look like. And then importantly, when to consider hiring someone outside the organization and possibly an attorney as well. What the practice looks like. When you hire me, what does that look like in terms of your interactions with the investigator? And then importantly, we're going to talk about some mistakes and how to avoid them when you work with an outside attorney investigator. And I'll give you some takeaways to leave things this morning. Okay. First of all, as Sarah mentioned, I hope you have questions. I want this to be interactive. So if something comes to mind that you want more clarity on or want to pose something, please enter that in the chat and we'll get those questions answered. Okay. Well, let's dive in. So we need to start sort of with this foundational element of, when does an employer have an obligation to do an investigation? Well, first of all, there may be legal reasons to do an investigation. There are laws on the books across the country and in every state that prohibit things like discrimination, harassment, and retaliation from occurring in the workplace. So if someone goes to HR and makes a complaint for sexual harassment or age discrimination, then that would prompt the employer to have to do some form of an investigation to determine what happened and whether those things were going on. Employers have, under the law, a obligation to take reasonable steps to prevent discrimination and harassment from occurring. And if it is something that happens, to prevent it from recurring. So doing an investigation is part and parcel with making sure that the employer's policies are being followed in terms of preventing things like harassment. What triggers that obligation? Well, it could be, as I said, someone goes to HR and files a complaint, but it can be a lot more nuanced than that as well. So if a manager or supervisor, for example, overhears a conversation that employees are having that could trigger sexual harassment concerns or other type of discrimination or harassment, then the employer may be on notice of a potential claim, which then triggers the obligation to investigate. So another reason why an employer may, outside of any legal requirement to investigate, do an investigation is that they have policies that may be triggered. So for example, one of the things that is not yet illegal in California has a lot of laws that protect employees' rights, as we all know. But one of the things that is not technically illegal under the law is bullying in the workplace. Now, harassment is illegal. So if the bullying is targeting somebody because of what we call a protected class, race, age, disability, then that might be illegal. But just good old fashioned threats in the workplace or teasing or that kind of thing, not yet illegal, but I would venture to say that most employers have policies that go above what the law says and outlaws things like workplace bullying. So an investigation may be necessary to determine whether an employer's policies have been violated and whether discipline is warranted. So the key takeaway on all of this is lots of reasons to investigate. And when we don't do investigations, bad things happen, to put it bluntly. So let's talk more about that. What happens when employees are doing things in the workplace they shouldn't, whether that's harassment or discrimination or bullying? Well, lots of negative repercussions can flow. And so one of the things that hopefully a good investigations program can help stave off are what's listed on this slide. So what happens when things go awry? We have people leaving. You have turnover in the office. You have loss of productivity when people are not feeling safe and comfortable at work. They don't do their jobs as well, frankly. So one business-related reason to prevent discrimination and harassment in the workplace is to make sure people are operating at their highest potential. So loss of productivity is another factor. Of course, people, if they're being sexually harassed, for example, in the workplace, may go to court and file lawsuits. They can go before that to administrative agencies and file charges of discrimination. Of course, if there is a case filed and a jury or judge finds in favor of the employee on their claim for harassment, then there can be high costs involved in that in terms of legal liability. So we want to avoid that. The other factor that always comes in is reputational harm. And this is a big one these days in terms of having social media presence. Outside of any potential legal findings against an employer, there can be really massive reputational risk to an employer if their name is being smeared, if their reputation is being smeared online with allegations of malfeasance. Right or wrong, it's hard to undo that. So we want to, as part of doing a good job in protecting our employees, be mindful of investigations as a tool to make sure that employees trust that their concerns are being taken seriously and that they trust the processes in place with your policies to look into and remedy potential legal issues. Okay, what are the core principles of every workplace investigation? And I'll start just by saying workplace investigations can be done internally by HR or compliance or legal. Sometimes larger organizations have legal departments that would conduct investigations internally, or they can be done externally by someone like myself. Whether it's internal or external, and we'll get to in a minute some considerations on whether it be done internally or externally. But no matter who's doing the investigation, these are three common core principles that should guide every investigation. Number one, the investigation needs to be prompt, reasonably prompt under the circumstances. So what does that mean? Well, it means you can't sit on them. Sometimes we have lots to do in our world as business owners or management, and it's really easy to put aside potential claims that we think may not be serious or that kind of thing. But the law says we have to promptly investigate and determine if there's an infraction when we have potential harassment or discrimination. Also, as the slide says, the delay can increase risk because evidence is only as good as what people remember sometimes, and people's memories start to fade very quickly. So we want to get on these things promptly. Impartial. This is a big one. The law and cases interpreting the law when it comes to workplace investigations require impartiality. So what does that mean? It means there can't be any actual or perceived conflicts of interest. Sometimes our HR internally may be friendly with people who are making claims or claims are about, or there's a lot of history between people and that impartiality could be challenged. That's one reason, and we'll talk about this, that you may want to go externally in hiring an investigator to make sure that the investigation has the appearance of impartiality and is impartial. And then finally, thoroughness. The investigation should be sufficient to withstand a challenge if down the line someone says, well, what did you actually do to determine whether this alleged conduct occurred? Did you interview available witnesses? Did you look at available documentation? Did you determine who was more credible in this case and who might be more reliable in terms of what they are saying? So these are all core principles that should guide every investigative process. Okay, what is an outside attorney investigator and what am I not? So let's start with the positives. What am I? I'm neutral, and that's part and parcel with being impartial. I am an independent fact finder. I am not an advocate for the employer. So, and this can be a little confusing because when I get engaged to do a workplace investigation for a client, I am being hired as an attorney. However, my engagement is very limited. It sets forth that I'm being hired specifically to conduct an impartial investigation. I am not being hired as the employer's general purpose legal counsel. I am not being hired to defend the company in court. I am not giving traditional legal advice about what to do to mitigate risk or that sort of thing. I stay in my lane as somebody that the employer can trust and feel good about is being neutral and thorough in their process. So I make at the end of my investigation factual determinations that I then present to the employer, usually in the form of some written report that allows the employer to rely on my factual findings to determine what to do. So I am a vehicle of information to the employer, not an advocate. So my work does go to preventing risk for the employer, but I am not looking out for the employer's interests other than it is in the employer's best interest to have a thorough and fair process that they can rely on. So hopefully that makes sense to everybody.
Alex, we do have a question from the group. They're wondering, what should we do when an employee reports a concern but says they don't want an investigation or asks us not to tell anyone?
It's a great question, and that does happen with some frequency. It's not up to the employee to determine whether an investigation occurs. So an employee might come to HR and say, I just want to get this off my chest. This is bothering me. I feel much better, but now don't do anything with it. That can be a tricky situation for HR to be in, but Bottom line, the employer has the obligation to do that investigation. Now, I would hope that the employer would talk to the employee about their apprehensions of what an investigation might do that they are scared of. They should be reassured, for example, that there won't be retaliation against them for making a complaint, that their matter will be kept reasonably confidential to the extent possible. So those are some things that I think should be done. But bottom line, there should be an investigation done. Okay. Let's get into when to hire an outside investigator, such as myself. These are some areas that I'm going to go through on this slide that might be ripe for going outside the organization to hire an outside attorney investigator. So first of all, if you have high level, high stakes types of claims, allegations that involve your senior leadership, your C-suite folks, or HR directly. I investigate lots of claims that are made against HR directors or HR managers. And one of the reasons for that is because how can you have somebody in human resources impartially investigate their director, right? At the very least, there'd be a perception that that could create a conflict of interest. Likewise, how can HR investigate their CEO, who ultimately is there in their chain, right? They're ultimately reporting to that person. So there would be a perception that they might be skewed in their assessment because they don't want to get fired or have other negative repercussions because that the person they're investigating is their boss. So those are sometimes areas where I do get involved in those higher level claims against leadership. Or when you just have very significant, serious allegations, serious sexual harassment allegations or retaliation. Retaliation is when somebody does something that the law protects, such as making a claim for harassment, and then they suffer in the workplace because of that action. So that's a very common claim for employees to make, but the law says, the employer has to treat those claims very seriously. And I get involved in those types of situations frequently. Higher profile public facing organizations. Again, here we're talking about the reputational risk. Sometimes employers in those situations just want to make sure that they can say publicly that they've hired a trained professional who does this for a living, who has credentials that they're going to rely on to help them sort this out. Another area is, you need to take stock of your own tools internally. As I said, employers can internally investigate their own issues, but you want to make sure that the people doing that are trained and qualified and know what they're doing. Because if not, that can be challenged and I've seen situations where a poorly conducted investigation can have negative ramifications as well. And we'll talk more about that as we go through. Kind of a follow-up to that last issue. If you've had breakdowns in the past, you're dealing with repeat offenders, so to speak, where it seems like this group is just generating investigation after investigation, and you've tried to do it internally and people aren't trusting the process anymore. That can be another reason to go outside. So here's sort of a decision tree following those principles on how to decide if going outside to hire an attorney investigator might be worthwhile. How serious the allegations are, whether they involve C-suite or executives. Could the neutrality of the investigator be questioned? Again, the investigations have to be done impartially. So to the extent that internal HR is friendly with or has a lot of experience with individuals, that can be an issue that needs to be looked at critically before the investigation is done internally. Is there likely litigation? If so, you may want to hire somebody who you feel like is going to be a good witness on the stand, because ultimately my work product, if I determine that somebody has engaged in sexual harassment in the workplace, that may lead to the employee being fired, which could in itself generate a lawsuit on the back end that the employee is claiming they were wrongfully terminated. Well, what that means is I may be called upon long after my investigation concludes to testify in a deposition or at trial about the thoroughness, impartiality, and good faith of my investigative process. So, you want somebody on the witness stand who's going to be a good advocate for their process and can withstand challenge to that process. So that's another consideration. Do you have trained internal folks that are available and have capacity to investigate? And then another thing about hiring an outside attorney investigator is that the investigative process can be privileged. So what that means is, because I am operating as an attorney, albeit for a more limited scope, my work product, our communications start with the assumption that they fall under the attorney-client privilege. Now, if the employer decides to use my investigation report to take an employment action like terminating an employee, that may then waive the privilege down the line. But we start with this assumption that it's privileged, which can be of added value to the employer. Basically, the more yes answers you have to these things, the greater consideration you should have to hiring someone like me as an outside attorney investigator.
Hey, Alex, we do have a question for you. How do we balance the need for prompt investigation with the reality that key people may be on leave, vacation, unavailable, or represented by counsel?
Good. Another good question. The key with promptness is reasonable, right? So those types of things, employee leaves, hiccups in process where someone's like, I'm going to get an attorney, so there's a delay there. That happens, but you want to be able to document those things in your file so that it doesn't look like you, the employer, or me as the investigator are the source of delay. So you just want to make sure that you're getting on things as reasonably prompt as you can. What the court doesn't want to see is that you got a complaint in April and it took you till June to assign out an investigator. Of course, things can happen during that process that might reasonably delay things, but you want to be as quick as possible. I don't need to get hired for everything. Let me just say that at the outset. There are lots of issues that come up in the workplace that don't require an outside attorney investigator to handle. Low stakes matters, routine policy violations, interpersonal conflict that does not involve claims of harassment or discrimination, or buzzwords like hostile work environment, which is a type of harassment. Claims where people are not saying I'm being treated differently because of my race or my sexual orientation or my veteran status. Now, on the flip side, if people are claiming that their protected classification is the source of their trouble, that may be a reason that you do want to take additional measures to consider hiring an outside attorney investigator. But for the minor routine stuff, performance-related issues, those can be and normally are handled internally. Now, all of this to say that frequently I get called by potential clients who say, we're considering hiring an outside investigator. Here are the issues. And I tell them, frankly, I don't think you need me so long as you have somebody internal that can handle this. It doesn't hit those yes answers to those questions that I'm looking at. So I'm happy having frank conversations to determine if I'm the right person to hire. And, other people that do my type of work feel the same way. So there's always, you can always test those types of questions with calls or outreaches to determine, what may be the best way to go about it.
Hey, Alex, we do have another question for you.
Great.
When you are hired, do you represent the company as their attorney? If so, how can you then be neutral?
So this is an interesting issue. So, and this is something that I may get challenged on when I'm deposed. I have been deposed a few times about my investigations, and I get asked a similar question. Hey, you're their attorney. I've seen your engagement letter. How can you be neutral? Don't you have a duty of loyalty to your client as their attorney? Yes, I have a duty of loyalty to my clients, but the key is my engagement sets forth the exact reason I'm being hired as that impartial attorney. So I am fulfilling my obligations to my clients by staying in my lane to do an objective, good faith investigation. So it's very specific in what I'm asked to do. I am not giving them legal advice. I am not operating in a way that wants to hide bad facts as I would perhaps if I was an advocate for them. So it really comes down to what I was hired to do. Okay. These are some bullet points on this slide that I've encountered in my years doing this about sometimes what employers expect versus what the reality is. And a lot of what I do in my world is educating clients or potential clients about what I do and what I don't do. So this is more of that. But sometimes my clients are like, just tell me what happened. We want to figure out who's lying. I don't do that. I don't tell you with absolute certainty what the truth is. The truth is not my guide. We'll talk about my standard of proof in a minute as far as what guides me in making my conclusions or determinations at the end of my investigation. But bottom line is I gather evidence in a way that tells me, and by nature of my report, tells my clients what more likely than not happened. I don't determine who's lying. I determine whose credibility or reliability is more reliable or more credible in helping me determine what more likely than not happened. I don't necessarily protect my clients from legal liability. Now, I think my process in going through a good faith process like mine does help them mitigate against risk. But ultimately, if I make findings that somebody acted in a way that they shouldn't have and there's legal liability, that may be the finding that I make, and my clients have to understand and deal with that. Do it quickly and cheaply. I need to do a thorough process. That process takes time and can create cost. So again, I'm not the one to do every potential investigation. You have to factor in whether the cost and the time it takes to do this is warranted based on those preliminary questions that we went through. And then I don't tell my clients on the back end, okay, these are the facts. Now, as your lawyer, here's what to do. That's more of an advocate's role that I don't fulfill. Okay. Let's talk about the life cycle of an investigation. So if somebody outside is hired to do an employment investigation, here's sort of how that might work in an overview. So initially we have a meeting, there's an engagement signed, we discuss the scope, and we'll talk more about that in a minute, but the scope refers to what questions am I being hired to answer? And we want to be careful in how that's phrased. I don't determine the scope. My clients tell me what they want investigated, and then they give me the discretion to do the investigation how I see fit, and ultimately to make the findings that I think are warranted based on the information. After the scope is defined, after I'm retained, then I may review background documentation or information, the party's complaint, whether that's a formal complaint or an email, or maybe it's a verbal complaint made to HR and their intake notes. I gather that initial information and review that at the outset. Then I determine kind of the order of operations of who I want to interview. Normally, I start with the complaining party and I sit down with them, either sit down in person or through Zoom. I would say old school me used to do everything in person, but since the pandemic and being forced to go through Zoom video conferencing to do interviews, I would say 90% of my work nowadays is done virtually. And it can be done very effectively virtually, and there's some cost savings there as well. But I decide who I want to speak with. I interview the complainant first to make sure I understand their concerns thoroughly. And then I go about my investigation, determining who I want to talk to next. Are there documents I want to review that came up during interviews that I think are relevant to look at? Is there potential video evidence? Do I want to look at card key swipes to determine when people arrived or left the office? All sorts of things can be potential evidence that I want to gather. And I'll talk to my client contact throughout the process, letting them know what I'd like to see and look at. Throughout this evidence gathering stage of my work, it's a continual assessment of what still may be out there. Am I done gathering information? Have I interviewed the people that I think may have relevant information? At some point, I determined that that stage, the evidence gathering stage, is concluded. And then I work on synthesizing that evidence that I've gathered in a fair and thorough way and developing a written report usually, which ultimately includes my findings of fact about what I think more likely than not happened. Then I deliver my report to my clients and I step aside. My engagement at this point is over. But importantly, and we'll get to this in a later slide, that doesn't stop the employer's obligation related to the investigation. They need to alert the parties about what happened in terms of what my findings were, protect against retaliation, and make decisions potentially about potential discipline to take. So that's sort of an overview of the process, and we're going to dig in on some important points so that you can understand it a little better now.
Hey, Alex, we do have a question for you.
Sure.
If we already started investigating internally and then realized that the matter is more serious than expected, is it too late to bring in an outside investigator?
No. And this happens with some frequency, that an employer will think they have one type of an investigation that can be handled no problem internally. They start meeting with the parties, and all of a sudden they have something very different than what they anticipated. So it's not too late at that point to pivot and say, I think we need to go outside and call me or someone like me to take on the cycle, the life cycle of the investigation at that point. We talked about defining the scope of the investigation at an early juncture, and this is really important. So I wanted to talk a little bit more about that and what it means. You want to have a clear scope. And again, this is the questions or issues that you're asking the outside investigator to uncover or to look into. That is determined by the employer. You want your scope to be sufficiently focused, but not overly narrow. So it's that sweet spot of having a scope that is broad enough to give you really helpful tools when the investigator provides their report at the end. What is a poor scope? And I've had this happen where an employer one time told me, we want you to investigate everything that's happened in this department that is now at odds with each other over the last 5 years. And I said, well, let's talk about that. Let's talk about what that might entail in terms of time that it will take me to investigate that, and importantly, cost. And when I gave them some specific numbers on both of those things, they were like, wow, let's talk about defining this a little more narrowly. So I can have conversations with my clients to help them determine if a scope might be appropriate or not, but ultimately it's their decision. You want to make sure, again, that your scope is sufficiently narrow to control costs. But one thing that can happen is what we in the world of investigations refer to as scope creep. So we may start by investigating, for example, a sexual harassment claim. But then I may get into an interview and somebody says, well, let me tell you about the race discrimination that I'm facing. So as the investigator, my job is to collect some information about that additional claim that is outside of my scope initially, present that back to my client contact and ask them, do you want me to add this potential issue to my scope or not? Again, it's their decision to make. They may make that decision in partnership with their own internal or outside counsel that can give them advice on that matter. But ultimately, they tell me what to investigate. I document my scope in my file. Sometimes my reports will say this other issue came up, but I was instructed not to investigate that. And so therefore it was outside the scope and I don't make findings on that herein. So again, scope is something, it's a dance, so to speak, between the employer and the investigator, and we want to be very clear on what the scope is. What do you give me as an outside attorney investigator at the outset to help me in my process? Well, I'm going to jump to the last bullet point on the left side of this slide. Things that I ask for. So the big picture is let me guide that process in terms of what I want to see. So ask me what you'd like to see. But usually it's initially complaint documentation, formal complaints, email complaints, that kind of thing. Usually I'm not making policy findings. Some investigators, outside investigators, do make policy findings, but I've found that I'm not oftentimes the expert in what the employer's policies say or how they're interpreted consistently. So I make factual determinations that the employer can then use to apply to their policies in determining whether a policy has been violated and discipline needs to be taken. That being said, I like to see employers' policies so that I can adopt language or be guided by them in making my factual determinations. Again, I want to make sure that my report at the end of the day is as helpful as possible to the employer in knowing what happened and deciding if steps need to be taken to remedy something. I frequently ask for organizational charts to help me get a lay of the land at the beginning. There may be a list of witnesses that the employer gives me. Be cautious there, and we'll talk about this potential risk in a second. But sometimes employers want to give me a list of everyone that they think I should talk to. That can be looked at by an outside objective party as trying to influence the investigation. Again, I don't know that it's a huge deal, but probably better to just let me guide the process as the outside investigator in terms of who I want to talk to after I've looked at the documentation and started getting into the investigation. Do you hand over the party's personnel files? I prefer not to have the personnel file at the outset of the investigation just because I don't want to be biased by things in there that may not be relevant to the scope of my investigation. So I probably won't ask for those, but there could be situations where I do want to see that. The goal of all of this is to help the investigator facilitate a complete and impartial investigative process. Don't have the appearance of selective disclosure or guiding the investigator in a way that could be looked at as influence. And don't withhold any records. I don't think this has happened. I may not know this has happened, where an employer withholds documentation that is relevant that I never get to see. But obviously, if that comes up, that can be used in litigation to undercut the good faith nature of the investigative process.
Hey, Alex, I have a question for you from the chat. If we get sued for discrimination, is there a value in having an investigation after the lawsuit was closed?
Maybe. It would depend on what information the lawsuit allowed you to understand about the case. If there, I guess, bottom line, if there are questions that you still have after a lawsuit about what may have happened to safeguard your employees from further damage, then an investigation may be warranted. So sometimes this comes up kind of an analogous situation. I get asked, well, the person that they're complaining about has left the company, so we don't need to investigate claims that they behaved inappropriately, right? Well, maybe, maybe not. The question is there a continued risk of harassment or discrimination? If the person's no longer there, then the answer might be no. But if there are other things at play that, maybe this person made a complaint about this other person and that complaint was not investigated promptly, or there were problems with the process internally under your policies, then an investigation may be warranted to determine, was there a breakdown in our policies that ultimately needs to be remedied? So I may do an investigation into the process and potential failures of that process. So bottom line is are there questions at the end of the litigation or the process that you still need answered to make sure that you're not running afoul of discrimination or harassment laws? Okay, credibility. We touched on this a minute ago. I often make credibility assessments as part of my work as an outside investigator. I determine who more likely is the more reliable party. If it's a he said, she said, or they said issue, no other witnesses, that doesn't mean I don't make a finding. I always make findings based on what I think is more likely than not to have happened, and assessing the more reliable person and their credibility is key to that. So these are some factors that every investigator can rely on and should rely on in determining credibility, corroboration being the big one. Is what this person's saying corroborated or supported by documents or what other witnesses say? On the flip side, is it not corroborated? Does this person say, yeah, you need to talk to Joe Smith, he's going to say the same thing as me, and I talk to Joe Smith and Joe Smith says, nah, it's the exact opposite? Well, that's a lack of corroboration, which can go against somebody's credibility. Is their report consistent, or is it changing? Is what they're alleging plausible given the entirety of the factual scenario? Does somebody have a motive to lie or fabricate their claims? And bottom line, the parties, either the complaining party or the responding party, frequently both have a motive to lie, to protect themselves from discipline, or to potentially protect themselves from being terminated. So again, none of these things mean that the person is lying or not telling the truth. They're all things that I would consider in helping determine who is more reliable and how much weight I put on individual statements or accounts. We talked a little bit about investigation reports. There's lots of different types of reports that can be generated by the investigator at the conclusion. Sometimes they're full reports with all citations to the evidentiary record. Sometimes I do summary reports, which are more truncated, but get to the bottom line of what I think happened. And sometimes I do oral reports. So again, I'm willing to, and I usually work with my clients and maybe their outside counsel on what the best fit in terms of a report is for the particular situation. All good reports will talk about these things on the left here: what was alleged, my methodology, who I interviewed, what standard of proof I used in determining what the facts are, what summary, it'll summarize the evidence I gathered, it'll talk about my conclusions, and importantly, we'll have a sound analysis so that the reader understands exactly why I determined what I determined. My reports are not a piece of advocacy. Again, I used to be an advocate. I used to be a litigator, and there was a switch I had to make when I came into this world of neutrality, where I wrote differently. And my early investigation reports are probably things I'd not want to look at now, because some words in there probably rang a little too advocacy-like. This clearly happened this way, something like that. So I want my language that I use in my reports to read like I'm an unbiased, impartial person. I'm not making legal arguments. I'm not making legal findings. I'm not making conclusions about whether something is harassment or discrimination. I'm determining who said what, on what occasion, the impact of that perhaps, and how many times it happened, so that the lawyers and the clients can look at my factual findings and determine potential risk and what they should do. I usually don't make recommendations in my reports. Sometimes I'm asked to do that by my clients. What do you think we should do? I personally don't like doing that because I think it looks a little bit like advocacy, and I want to stay on my side of being the neutral. There's some other reasons that recommendations might be things that I don't want to do. What happens if I make recommendations in a report that my clients ultimately don't follow? If that report is then discovered later on in litigation, that can be a problem for them. So for me, it's just cleaner for me to be the fact guy and not make recommendations. But if you're internal, if you're HR doing investigations, oftentimes you are also making recommendations. All right, we've danced around this topic of standard of proof, so I want to talk a little bit more about that. I am always making my findings based on the preponderance of the evidence, or more likely than not, greater than 50% probability about what happened. So if I sustain or substantiate an allegation of harassment, I say it's more likely than not that that occurred. Or on the flip side, it's more likely than not that it didn't occur if I do not sustain or substantiate the claim. All right, let's get kind of the back end of this presentation. Let's talk about some mistakes, so you can avoid these when hiring an outside investigator. Number one, don't delay. I'm going to talk about this one pretty quickly. We've talked about the why promptness is always something that we need to follow as a core principle of investigations, but delay also risks memories fading, evidence going away, employees thinking that the process is not being taken seriously. Lots of reasons not to delay. Number two, choosing an investigator based on cost alone. Let's just get this out there. Hiring an outside attorney investigator is probably a more costly choice than doing it internally. but what are the actual costs? If you have a poor investigation done internally or a quick investigation done internally that does not withstand challenge on the back end, that can actually be more costly in terms of litigation costs, employee turnover, reputational damage, et cetera, et cetera. So hiring an outside qualified attorney investigator helps ensure that the process is sound. While there can be a greater initial cost, ultimately you're purchasing insurance against claims down the line that your investigative process was biased in some way or not thorough. Don't promise confidentiality. So sometimes employers will send a letter out to the people that I'm about to talk to saying, what you tell the investigator is confidential. Not necessarily. I need to do my job. And part of that is giving the person who is claimed to have done things a fair and adequate chance to defend themselves. So they may have a right to understand who is making the allegation against them. What are specifically they alleging? So I can't guarantee, and nor should the employer guarantee, that my process will be absolutely confidential. It should be promised that it will be kept with discretion, that it will be on a need-to-know basis, and of course that they have a right not to be retaliated against. But you need to be careful about either promising or requiring employees maintain absolute confidentiality of the process. That's another consideration because under the National Labor Relations Act, blanket gag orders on employees saying you can't talk about this process may violate employees' rights to engage in what the NLRA terms concerted activity. So basically to talk with others about the conditions of their employment. So we can talk more about that if I'm hired or an attorney outside investigator is hired about what the employee should be told about confidentiality.
Hey, Alex, we have
Yes.
a question for you from the chat. If the facts support more clear and convincing, do you use language that indicates that? At my employer, many policies say preponderance, but the hearing bylaws require clear and convincing. So if facts support that, I have seen language that supports that higher standard.
Okay. So I pretty much always follow preponderance of the evidence. I don't know if you have language, you mentioned having some guidelines that talk about a clear and convincing standard. So that may be a reason to apply a higher threshold in determining the facts in your investigations. But in my world, I'm always following the preponderance of the evidence standard, which is the civil liability standard. If you go to court and sue for harassment or discrimination or retaliation, that's what the jury or judge would apply. So I guess on a case-by-case basis, you may have a higher standard, but I think it's unusual in most cases to apply that higher standard. Okay. Another thing you want to avoid is unintentionally or intentionally biasing the investigator. So often at the beginning of an investigative process, I may have a call with HR and they say, well, let me tell you about this person. This person is a train wreck. They've been making these allegations for years. We're going to hire you, but I'm sure you'll get a picture of what they're like pretty quickly. That I shouldn't be hearing that from the HR at the beginning. Why? Because it may bias me either unconsciously or consciously to think something about this person, to not take their complaint seriously. So you want to be very clear and careful and measured in talking with the outside investigator about the facts, or at least the facts as you understand them, to avoid biasing the investigator from the outset. And sometimes I get emails from my clients that might see the light of day in discovery and litigation that my clients shouldn't be sending me, telling me all sorts of things that they think about this person. So again, it's sometimes tricky to make sure that you're understanding, I'm not your general purpose lawyer. I am the impartial investigator. So you need to be careful about what you send me because it could come out in litigation down the road. Not preserving evidence. Don't destroy evidence or physical evidence that may be potentially related to the investigation. So I just had an investigation where my client did a search of somebody's work office, and ultimately they found some things that might be relevant, but they decided to get rid of them and destroy them. I quickly said, well, why are you doing that? And it was too late. So again, make sure that you're talking with the investigator throughout the process about what you should be doing to preserve evidence. If there are phones or computers that you need to ensure that what is captured on them doesn't go away, I can talk to you about that at the beginning and what maybe needs to happen in order to preserve the evidence. Because once it's gone, and then I may not have access to certain things that I'd want to see that could be used to undercut or weaken my investigative process. We talked a little bit about this already. Don't try to influence me. Don't try to guide me to interview certain witnesses. And I've had clients that have unfortunately done this. We can talk about if there's I have had situations where I've said, I want to talk to this person. The employer says, well, let's talk about that. This person left the employer in, pretty contentious situation. We had a lawsuit that they filed. So do you need this person? Well, maybe ultimately I say, you know what, I in good faith don't think I need that person, and I can defend that if asked about it in my deposition. But I have had situations where I say, you know what, I appreciate that, but I think that my investigation could be called to question if I don't try to interview this person. And if you tell me that I'm not interviewing this person, that needs to be documented in my file and perhaps my report. So there is some discussion that I have with my clients in that regard. Don't tell me that, I hope you find a certain way, because a finding against this person would be disastrous for the company. That's happened before. Likewise, don't tell me that, whatever you find, we're not going to do anything to this person. I had an investigation last year where my client essentially told me they're just going to have a slap on the wrist if you find against them. Again, that could unconsciously influence me to find against them, because I'm not going to be worried that they're going to lose their job or that kind of thing. So that may affect how I weigh the evidence. So just be mindful of what you tell me as far as influencing or unintentionally influencing my process. Don't confuse me with your outside general legal counsel. I had a situation just a few months ago where the client and the attorney were discussing very sensitive, privileged legal communications, and they decided to include me on those. I called the attorney and said, you don't want me on these. I'm going to return all these so you can preserve the privilege. So again, the roles need to be kept separate in terms of what I see as your outside investigator and what your general attorney might be looking at. Sometimes my clients at the back end of an investigation are unhappy with my findings because they appear equivocal. So I had a client once tell me, can't you make findings that are more certain? Your findings say it's more likely than not that this happened. Can't you say you definitely find that this happened? And again, it goes back to the standard of proof. My standard of proof isn't usually higher than preponderance of the evidence. It's not the truth. It is what more likely than not happened. And so I apply that consistently in my findings. And so I have conversations with my clients exactly that, about why it doesn't say this happened 100%, this happened absolutely, or this is the truth.
Hey, Alex, I do have a question for you. Yeah. How should HR respond when leadership has already formed a strong view about what happened before the investigation begins?
I mean, I think that's a risk, right? If you're putting the horses before the cart, so to speak, you're not doing a fair process. So this can be a reason, frankly, to go outside, to hire somebody outside, because you may have a situation where HR has investigated somebody 5 times, and each time this person has raised complaints, they've not been sustained. Well, is HR on that 6th complaint entirely unbiased and impartial, or are they already thinking this is going to be another waste of time? So I think there needs to be some honest head checking, so to speak, in terms of has HR or internal decided already what has happened? And that may be a really good reason to hire somebody with fresh eyes and a fresh perspective on it. I'm just looking at the time. I want to make sure we get through this. Make sure to keep me updated throughout the investigation process. So I had a case a couple of years ago where I was halfway done with the investigation, and I learned from one of the participants that there'd been a lawsuit filed, and the employer forgot to tell me that and present me with the legal documents in that lawsuit. So what that did in that case was, once they provided that to me, it made it so that I had to go back and re-interview witnesses, which added costs and time. So keeping me as the outside investigator apprised of key developments is important. Another thing that happens sometimes is I don't get told if somebody is about to go on vacation or even leave the employer. They're about to depart the company. Well, that would be something good for me to know so that I can be mindful in scheduling their interview to make sure that they're available to me. So again, keeping the outside investigator apprised of what they may need to know to help their process without influencing the process, that's the dance.
Hey, Alex, we do have another question for you.
Sure.
How to investigate managers that are covering for each other?
I guess I need to know a little bit more about what that means, but what it sounds like is an assessment of credibility. So I may get into a situation where I'm investigating complaints about one manager and I'm interviewing other managers, and I get a sense that they're not telling me the whole truth because they're covering for this other person. So ultimately, it gets down to me assessing credibility. And one thing that can be a factor, as I said, going against somebody's credibility is whether they have bias in favor of or against one of the parties. So this may be a situation where, based on the information that I receive, I think that this one manager is biased because they're supporting this other manager, so I don't put as much stock or weight into what they tell me. So that's a nuanced, tricky situation, but one that needs to be dealt with and assessed in determining credibility. So the final mistake we're talking through here is treating the report as the end. At the end of my process, I deliver my report. It says, this is what I think happened. Here's why I found the way I found. The employer at that point doesn't or shouldn't treat that as the end. They need to take what I find and determine if discipline is warranted. Determine what should happen. Again, they may be talking with their outside or internal legal representatives to guide them in that process. But then the other thing that they need to do is monitor the workplace against potential retaliation. So investigation concludes, you take action. Well, depending on the situation, the person who made the complaint may now get teased by others about being a tattletale or a whistleblower, and that can affect their work environment going forward. If that's the case, then that can be another claim that is potential, that has potential risk to it. So all this to say, an employer should continue to monitor the workplace after the investigation concludes to prevent against things like retaliation against the complaining parties, using the process as a starting point and not the finish line. Okay, we're wrapping up. I'm glad we're getting questions answered along the way. But let's talk about how to get the most out of an attorney investigator. Again, we've talked through these things. I just want to highlight them to leave you with. Choose your investigator, whether it's internal or external, based on what you believe their competence and skill level is, and if it's appropriately an issue that needs that outside, fresh perspective. Define the scope with the investigator, provide the investigator what they ask for. Respecting the investigator's independence is key. Keeping an open mind. We had that question posed about HR who had already determined what had happened. Try to avoid that and be prompt. Your key takeaways is, bottom line, you have a duty to investigate claims that might violate the law or your policies. You can't ignore those claims as much as you may want to. And you have to determine if it's an internal investigation or an external one that gets to the heart of the issues. Make sure that good investigations are adhering to those three principles of being prompt, impartial, and thorough. Decide if an outside attorney investigator can be an essential partner in certain situations. And the quality of the process matters as much as the outcome. So make sure that you're comfortable that with respect to each issue that you're looking at, you have a quality process that's defensible. with that, I think we're about out of time, guys. I just want to thank everybody for their participation. I just want to give a shout out. I'm very active in the Association of Workplace Investigators, and we offer a week-long training institute. So if you want to try to limit your costs of hiring an outside investigator, you may decide to really shore up your internal bench of trained, qualified attorney investigators. And I'm happy if you want to hit me up on LinkedIn or email me. I can provide more information about getting quality training through the association.
Well, Alex, thank you very much. You talked about promptness. We believe that promptness in anything is a good way to manage risk. So thank you again for the information on a very always timely topic. And everybody out there, thank you for joining us today. Our next BenderU is your company retirement plans, from fiduciary obligation to strategic opportunity. Please join us on Thursday, August 20th, 9:30 a.m. That information will be included in the recap for today's presentation. Thanks again and enjoy your day. Take care.
Thank you again to Roland and Alex for sharing their expertise with us today. We appreciate everyone taking time out of your busy schedule to join us for today's BenderU webinar. As a reminder, this session has been recorded, and both the recording link and a copy of today's slide deck will be emailed to you following the presentation. If any questions come up after today's webinar, please don't hesitate to reach out. Our team would be happy to continue the conversation and help determine whether outside investigation would be beneficial to your organization. Thank you again, and we hope you have a wonderful day.